Hi, folks. Denise Howell here, coming to you live from a lake in Kansas. Amanda Levendowski joins us today. Mike Keys and I are also on the show. We're going to look at Uber's battery tracking, Jochen D. Antwoord's style, a creepy experience of helping machines make moral decisions, and My Little Pony or My Little Phony. All this and more coming next up on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Emery Rohn, and Mike Keys. Episode 356, recorded August 12, 2016. Puppies and Kittens or Jaywalking Babies. This episode of This Week in Law is brought to you by Braintree. Looking to set up payments for your business? Braintree gives your app or website a payment solution that accepts just about every payment method with one simple integration. Plus, Braintree will give you the first $50,000 in transactions fee-free. To learn more, visit braintreepayments.com/TWiL. And by Blue Apron. Blue Apron will send you fresh, high-quality ingredients to cook delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 3 meals free with free shipping by going to blueapron.com/twit. That's blueapron.com/twit. And by Wealthfront. Wealthfront is a low-cost automated investment service and the most sophisticated way to invest your money. Whether you've got millions or you're just starting out, visit wealthfront.com/TWiL and sign up to get your free personalized investment portfolio. That's wealthfront.com/TWiL. Hi, folks. It's Denise Howell, and you're joining us for This Week in Law. Thank you so much for being here with us, where we talk about that tumultuous intersection between technology and law. Is law keeping up with the tech? Is tech doing strange things to the way the law is applied? Both things tend to be interesting and fertile subject matters for our show. We have a great group of folks joining together, 3 of us today. My co-host Mike Keys is here. Hello, Mike.
Hello, Denise. Welcome back.
Great to see you. Mike, of course, with the Dorsey and Whitney law firm up in Seattle. Thank you. It's great to be back. Mike and Emery quite ably helmed the ship last week in my absence. Thank you so much for doing that for me while I was out of town.
It was our pleasure.
We have a wonderful guest today. Amanda Levendowski is joining us. Amanda is a clinical teaching fellow with the Technology Law and Policy Clinic at NYU Law and a fellow with the Internet Law and Policy Foundry. She's also quite a Wikipedian. Hi, Amanda. Great to see you.
Hi. It's great to be here.
Lovely to have you on the show. We've been following your work and your excellent Twitter feed. In fact, I don't know if folks know this, but one of the great things about doing this show, we call it This Week in Law, but what we get to do in prepping the show is kind of this week in what's interesting to our guests. And we have a lot of Amanda's stories and things that she's been following and writing over the years and participating in the show today, which is going to make for some really interesting fodder. So let's start out and talk about some privacy stories. So one of the things you were following on Twitter this week, I noticed, Amanda, is this interesting tidbit that came up in an interview between Uber's CEO and it was NPR, I believe he was on, where he revealed that Uber tracks your phone battery and that there's this is something you specifically agree to in their terms of service. And they're doing so because they've found there's a direct correlation and users are willing to pay up to 9.9% more in surge pricing if their phone's battery is low. So it's a very strategic business move on Uber's part. And tracking battery life has sort of come to the fore because of this. I suppose there are many other services that might think it's interesting to know if your battery's about to go. For Uber in particular, it's a interesting reflection of where and how people are living these days, that as more and more phones have more and more wallet capabilities, you might be running around without any money or ID or the things that you typically carry around in your wallet and might need to make your way through the world. And if your phone dies, you might be very anxious to get to a place where you can charge it again. Tell us what caught your attention about this story and what are the ramifications as far as you're concerned?
Sure. One of the interesting things is that Uber's head of economic research talked about the fact that they're able to see what the battery life is, but there's not an indication yet that it's being capitalized to say, if your battery is low, you're going to be served up this up to 9.9 surge ranking. It's more of a, in the future, potentially, this would be really interesting trying to design that kind of interface for a company like Uber or really any other company. And what was surprising to me is that a number of both websites and apps look at battery life as a way to sort of optimize battery. If they see that your battery is low, they serve up a sort of low-tech version of the website or app to help conserve battery. But there are certainly ways that it could be exploited to capitalize on the fact that, like you said, Denise, if you are low on battery, you might not even know how to get to your final destination without the assistance of a phone, let alone have sort of the other necessities to let folks know that you might be late or that you are on your way home, or sort of the things that we take for granted when we're using a phone. And the other interesting issue was the head of economic research at Uber in that NPR interview. It was on the hidden brain, and it was about other factors that sort of Uber and other companies look at when making pricing decisions. And one of them was if the pricing is something like 2.1 versus 2.0 is the surge price, customers are more likely to accept it because they assume there's some sort of fancy behind the scenes algorithm that's serving up a surge price with such precision, which is really no different than the 99-cent ending to make folks feel like they're buying something that's a bargain rather than jumping it up to the next dollar value. Really interesting issues about how to price these kinds of services.
Yes, thanks for catching me there. It was Keith Chen, Uber's head of economic research, that did the interview entitled "This Is Your Brain on Uber" with NPR. What do you think about the fact that users agree to this when they download and use the app? Is this the kind of provision in a privacy or terms of use policy that might not be enforceable, that might run afoul of privacy laws, or do you think this is fair game?
I don't know about whether it would run afoul of laws, but based on the feedback that I got after I mentioned the article, I sort of set it as a reminder, because on your phone there is a low battery setting, at least on iPhones, and people were really surprised. And I don't think that it's the kind of thing that folks expect apps to be able to see. Or even websites. There's really interesting new research that builds on prior research from last year from Princeton. And they were able to, using that kind of feedback between, this particular issue was on websites, but between websites and mobile devices, sort of create a fingerprint between the battery level of the computer looking at the website, or the device looking at the website, and the device itself, which I certainly don't think is something that customers or viewers expect, even if they are receiving sort of a mobile optimized or battery friendly version of the site when they're viewing it.
So is the way that this works then, they can only track your battery usage if you have that switch to battery saving mode feature toggled on?
No, it doesn't seem to be the case, because the way that the battery is or that sort of low battery is communicating, the low battery switch on the phone changes all over across the interface, what apps are serving up, or potentially what, if you're using a web browser, might be served up. But apps also have the ability to customize that for themselves, and websites do as well. So even if the switch is not flipped on your phone necessarily, it's still possible to communicate that battery information.
Mike, what do you think about all this?
Wow. Well, So the thing that wasn't clear to me after reading the article was, although Mr. Chen said we haven't tried to monetize on this, Amanda, I'm curious, how were they able to discern that a user would be would pay up to 9.9 times more on top of the regular fare when they have a low battery? Is this something? Did they use consumer survey research of some sort? How did they come up with that?
It sounds like it was through the inter-app data. So they were able to look at, here's what customers are paying when there's already surge pricing for sort of a totally unrelated reason, say a rainstorm. If there's a rainstorm and folks are willing to accept the surge pricing more when their battery is low, it would be from the in-app data that sort of conclusion or correlation could be drawn from.
Interesting.
So the one thing I thought in reading through all this and considering, how are people defending against this, fending off being subjected to surge pricing if their battery goes down, is that perhaps Pokemon Go is actually our savior in this regard, because a unrelated but interesting statistic from research firm NPD Group, which runs a retail tracking service, as reported by USA Today, is that between July 10th and July 23rd, during peak usage of Pokemon Go, sales of portable power packs for charging smartphones and tablets doubled. So if you're a Pokemon Go user, perhaps you are insulated from this because you are packing your power pack.
Even if you're one of those Pokemon Go folks who've sort of trailed off in the more recent weeks, keep the battery pack. It seems like it's going to have a lot more value as more apps end up thinking about or potentially monetizing on whether your battery is low and you're in need of services.
Yeah, my particular situation was I had a battery pack that was solar, and it stopped working. It worked for a couple of years and then just wouldn't charge anymore. So coincidentally, I needed a new battery pack right when Pokemon Go came out. I won't blame it on the app at all.
So you're just there to inflate the statistics about this surge in battery.
That's right.
And battery pack sales. That makes sense.
That's right. Yes. But I did learn as we were running around New York, your neck of the woods, Amanda, last week, that the variety of battery packs that are available out there are quite extensive, and they've gotten really thin and slim and, hardly obtrusive at all to carry around. So perhaps now that we know that Uber's using this, or potentially will use this data to our detriment, that'll boost battery sales as well. Let's move on to another privacy-related story involving a case that is pending against a drug dealer that really highlights the state of emails as evidence and what you can learn by pushing back on the evidence that's submitted in a case. This was written up by Tim Cushing at TechDirt, and this is a case only tangentially involving Yahoo, who's in the middle of this because the drug dealer in question had a Yahoo email account, and the prosecution has been introducing emails from that account, even though Yahoo's policies state that the 6 months of deleted emails that were recovered shouldn't have been able to be recovered. So what the defense lawyers are properly doing is making sure that the evidentiary chain of the emails is sufficient for them to be admissible and reliable in court. So they're trying to get all kinds of information about, well, Yahoo, you say you shouldn't have had these emails, and yet you do. And how is that taking place? So if anybody's seen the new Jason Bourne movie, I don't want to spoil it for you, but let's just say that this plot is tracking right along with what could have been going on there. Mike, do you think that the court will require Yahoo to establish how they have these emails that they shouldn't have?
Yeah, it seems like the court might be going that way. Based on what I reviewed, it sounds like the court was a little bit concerned with some of the inconsistencies that were presented through the evidence as to how these emails were retained or not retained. So, I could see a court, given the recent headlines with respect to the NSA and privacy being such a big deal and government surveillance kind of at the forefront, I could see a court wanting to look into this a little bit further and find out. It seemed, at least as based on the accounts that I read, I believe it wasn't necessarily sent emails that were sent by this drug dealer to some of his confederates, but it was actually draft emails where these folks would sign up for the same account. You'd go to draft an email, you'd leave the message for your confederate in draft form, and then your confederate would later go and log onto the account and look at that draft email and then reply. So actually nothing, at least I don't believe anything was necessarily going through any sort of network. It was just kind of residing somewhere in draft form. So it seemed, I guess, maybe a little bit more suspicious or curious as to draft emails as to how those would be saved and ultimately recovered. So very intriguing.
Right. Yeah, I haven't gone too deep into the details of that either, but what does seem to be curious here is that what they're interested in is deleted emails. So maybe what they were doing is reading the drafts and then deleting them. And like you said, nothing's getting transmitted. And Yahoo's policies on deleted emails said one thing, but here are the emails coming up in the case against them. So an interesting reminder that the rules of evidence are out there and applicable, and that prosecutors have to comply with them in court, and so do service providers. Amanda, what do you think about all this?
It reminds me a little bit of after the Ashley Madison hacks, where a number of account holders were shocked that their information was still available months or years after they'd signed up, and thought that they'd successfully nuked their accounts using what was described as a sort of a delete all feature, when in fact that was not the case. And I think that companies, like Ashley Madison and potentially in this case, misrepresent the ephemerality of those kinds of communications or what they withhold at their peril. It can definitely come up as an issue, as we're seeing here in litigation. I'm also really interested in the fact that, the criminal defense lawyers are very savvy about these technological issues now. That oftentimes they're on the forefront of saying, this seems a little fishy. We want to know how this information got gathered, how this evidence, what the theory of bringing this evidence in as authenticated under the rules of evidence would be. And they're the ones who are really pushing for a little bit more transparency and understandability. And this judge seems to take it seriously, since the judge ordered discovery in the case.
Yes, so that'll be an interesting one to watch. Apparently the defense lawyers asked for a whole bunch of information. The judge backed that off a bit, but is going to hold Yahoo to submit enough of a explanation here that the judge can make an analysis whether these are reliable and admissible in the case. So go ahead.
Oh, go ahead. So, the other thing that strikes me about this scenario is the whole notion of Fourth Amendment protection in these days. The standard is whether there's a reasonable expectation of privacy with respect to this search. And more, given the tremendous amount of surveillance, given the tremendous amount of how just our society is completely digitized and linked in and networked together, it seems like there's probably a reasonable argument to say when you put something online, even if you're using it in draft form, a draft email, that do you really have an expectation of privacy? I mean, maybe you still do, and maybe people think that that is something that's private and that nobody's watching. But I guess I always think that anything that you put out there, it doesn't matter what terms of service say or what anything else says. You would think that the level of expectation of privacy has got to be pretty low and kind of sinking lower and lower as we plow further through the fields of technology here. So,
well, and this is one of those. this is one of those instances where the law has not kept up with technology and people's expectations. I think that if you were to go around telling people, hey, you know, all your emails using that online service and everything in the deleted folder, everything in the draft folder, those drafts that you were writing just to get something off your chest but never intended to send, those are, you know, you have no reasonable expectation of privacy in those. I think people would go, what? So that's one of those areas where I think that our legislature needs to get off its butt and rethink how privacy laws should apply to electronic storage and email in particular. Us make undelete our first MCLE passphrase for this episode of This Week in Law. We put these phrases in case you are watching and or listening and or a lawyer or another professional who might be able to get professional credit in your field for watching and listening to the show. We put these phrases in case you live in a jurisdiction that makes you verify that you have actually watched or listened rather than just writing it down and submitting what you need to submit. If you need more information about that, would like more information about that, if you go to wiki.twit.tv/thisweekinlaw, you will find our show page there and a wonderful table of information on the 50 jurisdictions in the U.S. for U.S. lawyers who might be interested in doing this. So undelete is our first phrase, and we'll have another one later in the show. We'd also like to thank our first sponsor for this episode of This Week in Law. We're going to come back in a moment and talk about digital hell. But before we do, I want to tell you about Braintree, which is code for easy mobile payments. Maybe you're working on the next Uber, Airbnb, or GitHub. Then why not use the same simple payment solution that helped them become what they are today? Braintree makes mobile payments so fast, easy, and seamless, it's almost magical. Add it to your app with just a few lines of code, and you're instantly ready to accept Apple Pay, Android Pay, PayPal, Venmo, credit cards, even Bitcoin. And if some other way to pay comes along, Braintree will support that too. Braintree's fast payouts and continuous support mean you'll always be ready, whether you're earning your first dollar or your billionth. See fewer abandoned carts and more sales with Braintree's best-in-class mobile checkout experience. Braintree gives you a full-stack payment solution, support for all payment types your customers might want, single integration across all platforms with superior fraud protection, customer service, and fast payouts. To check it out for yourself, visit BraintreePayments.com/TWiL. Thank you so much, Braintree, for your support of This Week in Law. So let's talk about digital hell for a moment. This is a fascinating story that was broken by and has been followed up on by Cash Hill, writing for Fusion. A couple in Kansas live in a very interesting spot. Can you tell us more about this, Amanda?
Sure. So they live in a rural area, a farm, and that particular place was decided by a map company as basically middle America. And as a result, when IP addresses in the United States cannot resolve to, say, your actual computer or mobile device, they default to this middle America device, this location that is totally made up but happens to correspond to a very real place occupied by real people. And the sort of fallout of that is that when mobile devices go missing or, investigators are tracking illegal activity, but the IP address is shielded in some way, it defaults to this address for these folks' farm. And they've received just death threats, investigators tooling around thinking that they're engaged in illegal activity. And if you sort of think about what that map might look like of what is showing up at that IP address, it would just be thousands on thousands of connected devices, which are not actually there and are the exact result of a map-making company just sort of making up a location without realizing that if that location is a real place and real people live there, it has a very serious real-world impact.
So I'm curious why there has to be a default location for IP addresses that can't otherwise be pinpointed. Why did they even decide to pick some random location?
I assume that the reason is because they would want to know whether it's in the United States or abroad. Now, there's not necessarily a reason to pick sort of a farm that actual people live on. It could just as easily be sort of the business site of the particular organization or map maker or tracker. But, in this particular instance, it sounds like they didn't think that much about whether they were going to pick a real place or a random place. And in fact, in one of the interviews with somebody who works for that company, they sort of said, we didn't really think that a real group of folks could live in the place we picked. It was random.
Right. And they've now moved the default lost device IP address location to a lake so that it will no longer pester these folks. But that hasn't stopped them from suing. They have sued MaxMind. I was trying to determine on what grounds. Their complaint is a little bit short and vague, but they do assert claims of emotional distress, false light, because it makes it seem like they might be the defendants in these cases that are being investigated, I suppose is the theory of that. And also invasion of privacy, and they're seeking $75,000. So I'm sure we'll hear that argument in the case. It's a good one, Amanda, that perhaps you shouldn't have picked our farm. Perhaps you should have picked your headquarters.
Well, and now they have a lake. They have a lake, and so hopefully they've thought through the issues of if people go into that lake looking for a mobile device, sort of in the office theme of I'm following directions and going to where it's telling me. I hope they thought that through as well.
Yes, exactly. Now we'll be hearing from wildlife agencies about the poor tortured animals being dredged out of the lake. Yes. Mike, are you planning to move to digital hell anytime soon?
No, I found this story so fascinating, though. I couldn't believe it. And the lawsuit, I think, is interesting. It seems as though, they probably have some issues here, whether this would really be a foreseeable type of problem that the digital mapping companies should have thought about. They certainly should think about it now, to Amanda's point about the lake. But at the time, you would think this would probably be some innocuous decision that was made and nobody ever thought about it. And certainly no one ever thought that it would cause all this undue strife and grief to this poor couple that moved onto that farm. So very, very interesting.
Right. So Virgil in IRC is asking whether self-driving cars would go into the lake. I'm just envisioning all of the automated law enforcement technology barreling right there, because that's where it says the device is.
And it's
what
not
were you
I was going to say that the map making error is not the only way for sort of these digital hells to sort of emerge. Reply All did an interesting podcast with a couple who lives in Southwest Atlanta and has a very similar issue of folks showing up to their house saying, "You've got my phone." This couple saying, we don't know what you're talking about. And, as you can imagine, that can get incredibly confrontational and angry when people believe that you have their stolen mobile device and you keep saying, I really don't. And their issue didn't seem to be from a digital map maker's error or a default IP address. It was more that they have this bizarre misfortune of living in sort of the digital desert. There's not a good way to triangulate IP addresses, and so it happens to default to their address, but it's not because of a setting made by a company. It's a totally separate issue about sort of bouncing around cell towers and figuring out, the GPS location.
God, how awful. And my kid liked to talk, taking it right on back to Pokemon Go again. We lived in a place where a lot of Dratini were spawning. And my kid liked to talk about how it was enhancing our property values. I'm afraid the folks you're discussing have just the opposite problem for similar digital, invisible reasons. Let's move on to talk about law and Wikipedia and the maturation of Wikipedia as a source that helps the legal process unfold. So let's look at the social web. Amanda, I imagine you have a great perspective on this, having both an interest in law and Wikipedia and having been an active Wikipedia editor since college, I believe?
Yeah, that's right, since college.
So I'm sure that you, like Mike and I in our practices, have seen a maturation of the role of Wikipedia in the law. Could you sort of lay out the groundwork for folks who haven't been following this as we have? What were things like back then, and what are they like now?
So even back as early as 2007, there was an awareness that there was this new online free encyclopedia that anybody could edit, and judges were considering how to approach it, both from what happens when counsel presents it as sort of evidence or in support of an argument or cites to it, and then also from the court's perspective, is it appropriate for a court to cite to Wikipedia? And in 2007, the New York Times did a pretty fascinating and kind of ahead of its time piece about whether courts should be turning to Wikipedia, called Courts Turn to Wikipedia, but Selectively. And there was a great interview or sort of quotes with Cass Sunstein and Judge Posner from the Seventh Circuit. And Cass Sunstein's response was sort of, I love Wikipedia, but I don't necessarily know that it's appropriate as a judicial resource yet. And Judge Posner's response was, Wikipedia is a terrific resource. And that's really borne out in the breakdowns of how different federal courts have cited to Wikipedia since, prior to 2007 and all the way up till now.
I know it's not unusual at all now to see citations to Wikipedia in legal opinions. Do you think that there are people out there who still hand-wring about this? Is it still controversial, or has Wikipedia totally come into its own?
I definitely think that there are folks who are skeptical about whether Wikipedia has an appropriate place in sort of legal scholarship. But that being said, 1,300 different state and federal courts have mentioned Wikipedia in written decisions. About 1,000 cases of those are federal, and 185-ish of those cases are in circuit courts. And at this point, every single circuit court has mentioned Wikipedia in a decision. And as I mentioned earlier, Judge Posner said that he loves Wikipedia. He thinks it's a terrific resource. And that actually bears out in the circuit court data. The Seventh Circuit is leading in Wikipedia mentions in its decisions with about almost 90 mentions, I think, at last count. And the next closest circuit is the Ninth Circuit, and it's not close. I think there's something like 20 mentions in Ninth Circuit decisions that reference Wikipedia.
No Supreme Court opinions yet?
I don't believe there have been any Supreme Court decisions yet, but there have been a couple of really interesting lower court cases that show the different ways that Wikipedia can either be used in an opinion or become part of the case. On the one hand, there's a lot of judges, and obviously their clerks as well, are part of this change and this shift in citing or mentioning Wikipedia, in that it's sort of dropped in for color or flavor. You make a pop culture reference, you cite to the Wikipedia article as the resource, and that's sort of a simple, insular way. There have been a couple of cases in which the Wikipedia article itself is guiding to the court. There was a case in Utah in which the judge said that, the subject, I believe, was about sort of whether a jet ski was a particular classification under an insurance policy. And the judge said, this subject is well illuminated in that great repository of contemporary wisdom, Wikipedia, which I think is such a great quote, because if you're looking for how people understand a particular word, Wikipedia actually can provide a really helpful insight into what people think of when they think of a word. And then another way that Wikipedia has come up in court decisions is with technology. For new cutting edge issues that won't necessarily have sort of an encyclopedia or more traditional resource, Wikipedia is the place. And I've seen a good example is in a lawsuit here in New York, a criminal decision in People versus Barber. It was one of the first revenge porn cases here in New York, if not the first revenge porn case. And the court said, this phenomenon is so common that there's even a Wikipedia article about it, and cited to the Wikipedia article.
Mm-hmm. Yes, and I'm sure we should have asked this of the Wikimedia folks that we had on the show several episodes back. Really interesting one to go back and listen to if you have not yet. But we covered a bunch of things with them about how people use Wikipedia to enhance their own knowledge of legal issues, and the pros and cons of that. What I wish we had asked them, given the discussion we're having today, is how many frivolous lawsuits Wikimedia gets hit with for people who are unhappy with either their corporate Wikipedia page or a personal one that may contain inaccuracies. Do you have any insight into that?
No, but I would love to go back to the point you made about how lawyers use Wikipedia to sort of get a better focus on issues. And I think that, especially amongst young associates in law firms and potentially law clerks, it's a good place to start. You know, you can go and get a sort of high-level overview of a particular topic or area of law that you may have no familiarity with. A lot of the time, the key decisions, particularly Supreme Court decisions, which are all freely available online, have links directly to what you're looking for, which is a money saver if you don't want to dive right into Westlaw searching. And for me personally, I was doing a bunch of research about revenge porn and saw there wasn't a Wikipedia article. And I gathered all these primary sources and sort of thought, well, why don't we create an article? And then there is something that people can go to and see, here's the current state of the law. Here are laws that have been introduced. Here's some background and foundational information about the history of non-consensual pornography. And I think that that's a great way for law students to use Wikipedia to, you know, they're doing all this research, not necessarily original research to come to sort of a creative conclusion, but just factual research about what the state of play in the law is and what the current issues are. And taking that factual information and including it in an article is a huge value add, even if it's just adding a proper Blue Book citation to the full freely available link to a court case. That's very helpful for the next folks who come along to look at that issue.
Right. I think if I were learning to practice law in today's day and age, Wikipedia would be a huge part of my resource toolbox. Simply to, as you say, to get the overview, to get that, you know, line of cases that you need to then delve deeper into and research and make sure you know, each and every one of them inside and out. Mike, I don't want to go too far into the internal workings of your firm, but I'm just wondering what your take on this, how you feel when associates come to you with information that they've gathered from Wikipedia. Is that a problem in your practice, or do you just consider it part and parcel of where we are right now?
No, I don't view it as a problem at all to use as a resource tool. I use it frequently myself. I've actually used, I don't know that I used Wikipedia. I know I used Webopedia, which is a database of various technological terms. I had a software copyright case a couple of years ago where some of the definitions were very useful, and we used them in the course of deposition. So I think it can be a great tool. My concern, though, is whether there's not enough reliability. I think it could be a very reliable resource. But my concern would be using it in the course of litigation and having a court consider it based on the anonymity associated with it. As I understand, I've never written for Wikipedia, and Amanda, maybe you can clarify this for us, but isn't it true that you could submit, not you necessarily, but anybody could submit an anonymous entry into Wikipedia, and you could use that and fashion it in the way that you wanted to present facts in a particular way, and then that could ultimately be used and submitted to the court? In other words, could somebody, if they wanted to be dishonest or otherwise not very forthcoming, use this in a way that would be problematic and dishonest?
Mike, that's a great question. And actually, even if you're editing, quote, anonymously on Wikipedia, the IP address is captured. Now, if you're using a VPN, the IP address might not necessarily correspond to where you are in real life, but it actually cuts both ways. So say you are a company that has sort of added some helpful information to the Wikipedia page that makes your company look better. If a smart attorney, and I've done this in practice before, looks at the Wikipedia page and says, this seems incredibly praising of the company, go look at the article history. It's very easy to audit who makes changes to Wikipedia articles and when they were made. So if you go into that edit history and see, even if it's an anonymous IP address, it's an IP address, you can look it up and see whether it's associated with the corporation. You can see that it was made right before perhaps the complaint was filed or perhaps before discovery closed. And now you know a lot more information about the opponent's approach to this litigation because they went in and tried to manufacture evidence in an ongoing litigation. Or even if they added positive information well before the litigation as sort of a PR overhaul, it's still very helpful to know that they might have added or sort of slanted that information. And I think that that's sometimes information that's really interesting to a judge.
I wonder if
that would be incredibly interesting if a company went in and ginned up their own Wikipedia site and then used it in the course of litigation. Very interesting. This discussion, I think we're definitely seeing courts embracing this sort of evidence. It reminds me of a recent case. It's a district court case, and I forget exactly where it dealt with the issue of using the Wayback Machine as evidence.
Absolutely.
And the court said, hey, this is certainly a reliable resource. The Internet Archive has been out there for many years. It has a well-known process and procedure for capturing web pages, and the court absolutely considered it and said that it was reliable. So I think we're going to see more and more of this. And Amanda, I think you raise a great point about how if somebody wants to play behind the scenes and be a little devious, there are ways to potentially tease that out through the litigation process. So,
absolutely. And I think that the same year that New York Times article about the reliability of Wikipedia and its citations in courts came out, the Southern District issued an opinion basically saying, even in 2007, so many courts have cited to or mentioned Wikipedia that it's clear that at least some folks don't find it to be, quote, inherently unreliable. And there the court, as you mentioned earlier about the issues around whether something could be admissible as evidence, Mike, the court said this is a sort of issue of weight, not admissibility. No different than if an expert relied on what you, counsel, believe to be a biased resource. Take it up on cross, take it up in a motion, but that's not going to be dispositive just because it's an internet resource. That's sort of your job to figure out whether or not to take that seriously, and to if you don't believe that it's reliable, to tease out the facts that undermine its reliability as a resource.
I'm just hoping Wikipedia keeps track of how many of those IP addresses originate from a lake in Kansas. So then we can really get down to it.
One other question on this, yes, which I've always been curious about, and Amanda, maybe you can help us out on this. When you type anything into Google, a search term, Wikipedia is always, if not always at the top, it's always right in there, or at least frequently on the searches that I do. Is that just because there's so many different websites that point to it, and that's how the Google process works in terms of presenting search results, or is there something else going on here?
I mean, as you know, Mike, like the sort of SEO Google algorithm is quite unknowable. But I do think that the fact that Wikipedia is such a go-to resource, it's so widely used, does make it a sort of common sense placement to put it up at the top. That's what people are looking for a lot of the time. And it makes sense if you're trying to give folks what they're looking for as quickly as possible to put something like Wikipedia up at the top. But I'm not sure exactly what the mechanisms that place it there are. It's part of the Google machine.
Yeah, I'm invariably glad that it's there. I was glad that it was there in getting ready for the show today to help me know more about, God, what are they called? Antwoord. We're going to talk about them later in the show. As I now know, a rap rave band. So we will get to them a little bit later. But before we do that, we're going to thank our second sponsor for this episode of This Week in Law, and that is Blue Apron. Blue Apron's mission is to make incredible home cooking accessible to everyone while supporting a more sustainable food system, setting the highest standards for ingredients, and building a community of home chefs. Blue Apron delivers seasonal recipes along with high-quality ingredients to make delicious home-cooked meals. Each meal comes with a step-by-step, easy-to-follow recipe card and pre-portioned ingredients that can be prepared in 40 minutes or less. Save time and money. Shopping at the grocery store is 60% more expensive than Blue Apron. If you spend a lot eating out or at high-end grocery chains, you can now spend under $10 per person for healthy home-cooked meals. Customize your recipes every week based on your dietary preferences and choose a delivery option that fits your needs. There's no weekly commitment, so you only get deliveries when you want them. Blue Apron now delivers to 99% of the continental U.S. This is one of my favorite features of the service, is you can tailor exactly how often you want it delivered, how much you want delivered, and from that week's selections, exactly what you want to give a try in your own kitchen. I find myself logging in once a week or so just to look at my upcoming deliveries and make sure that what I'm getting is arriving when I want it and is going to consist of exactly what I want to come. So it's great that they allow you to tailor it in that way. Blue Apron also sets the highest quality standards for their community of over 150 local farms, fisheries, and ranchers across the United States. You can feel really good about the food you're eating because seafood is sourced sustainably, beef is raised humanely, chickens are free range, pork is raised naturally, and regenerative farming practices are used for produce. By shipping the exact amount required for the recipe, Blue Apron is reducing food waste. Hallelujah. That's my worst thing about shopping frequently at the grocery store, is having lots of fresh produce in the house is a great thing, but it's difficult to gauge exactly how much you need for each meal. And that's what Blue Apron does beautifully for you. Whether it's Japanese ramen noodles, wild-caught Alaskan salmon, or heirloom tomatoes, Blue Apron brings you the very best. Blue Apron not only supports a more sustainable food system, it also supports happy and healthy families. Cooking together builds strong family bonds, and research shows that Blue Apron families cook nearly 3 times more often. New recipes are created every week by Blue Apron's culinary team and are not repeated within a year. Spiced pork burgers with goat cheese and cucumber corn salad is one kind of thing you could get. Summer vegetables with quinoa and fairy tale eggplants, shishito peppers and corn, chicken tingo tacos with summer squash and tomato salsa. And as far as my family goes, we love eating good food. None of us are cordon bleu trained chefs. All of us are busy and not spending time poring over cookbooks. So to have wonderful sort of unusual ingredients blended together in a flavorful and creative way, have that all thought out for us is just a godsend. Check out this week's menu and get your first 3 meals free with free shipping by going to blueapron.com/twit. You will love how good it feels and tastes to create incredible home-cooked meals with Blue Apron. So don't wait. Visit blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. Amanda, was there anything else you wanted to add to this Wikipedia discussion before we move on?
No, other than to say that I would really encourage folks to edit, get some experience. You don't have to be an expert. Even if you just clean up a typo, it's always appreciated to have even those minor edits fixed by somebody. So I'd really encourage people not to be overwhelmed or intimidated by editing Wikipedia. It's a fun community, and it can be a really great experience. I know that I've had a really good experience editing Wikipedia so far.
Yes, and we're going to talk about that as part of our tip of the week later in the show. Exactly the great things you can discover by deciding to edit a Wikipedia page, not just by fixing a typo, but more in depth should you decide to take that plunge. Let's talk real briefly now, though, about the Yahoo acquisition by Verizon. Not too much on the legal front to discuss there. Unless perhaps folks want to get into antitrust issues. That's not really why I flagged the show this week, though. Why I did, and the antitrust issues come up because of consolidation of media companies. I think with this acquisition, Yahoo now becomes the 3rd biggest internet property after Google and, God, I forget who number 2 is. We have some infographics about that, though, linked in our discussion points. If you're interested, you can go to tagpacker.com/user/thisweekinlaw. Everything we're talking about on the show today will be there under episode 356. But the reason I flagged the sale is just, there are a lot of services that Yahoo users are using that are now going to be under the Verizon umbrella. And I'm sure people are interested in exactly what happens to their data in this kind of situation, another sort of terms of service / privacy issue that comes into play. Vindu Goel at the New York Times did a nice piece addressing some of those concerns and wants you to know that if you're a Flickr user, Yahoo Mail user, etc., These are successful services that it appears that Verizon will keep separate, and things should continue to operate as they have been. Tim Armstrong, the chief executive of Verizon's AOL unit, says that Yahoo is one of the most powerful brands in the planet and that they will be investing in it. So you can have some assurance that your data at least is not going to go away, and that your services are going to stay as well. And the deal itself is not expected to close until early next year. So you have at least until then to think about all of this. And your personal data, sharing it with Yahoo's advertisers, et cetera, will Verizon use Yahoo search information to try and sell you ads on your phone? The FCC has actually fined Verizon for tracking people's cell phone browsing habits without their consent. So now Verizon is banned from sharing data across its business units unless it gets the user's permission. So another good thing just to bear in mind as you're considering what all that will mean to you. Any further thoughts on this, Amanda?
No, that was a great recap and overview and really helpful advice for folks who might be concerned about their data.
Yes, and again, folks should go to that New York Times article if you are interested in even more about that. Let us move on to another topic of discussion. Let's look at some issues related to legislation and policy. Speaking of the FCC and how your data is used and gathered, there's an interesting discussion. It's not a new discussion. It's something that has been sort of a give and take that on the privacy front that regulators have looked at for a long time. And that is how much of your data should you have to exchange to get the services that you're provided with. And when this kind of topic comes up, I always think back to those people PCs that were around in the late 90s, which basically were giving you free internet access as long as you agreed to accept ads. And I bring this up so much on the show that I'm officially adding people PC references to the unofficial This Week in Law drinking game, supplementing anything in Latin, references to Star Trek, Star Wars, and Monty Python, and the early days of blogging. So now you have something else to help you enjoy the show as you play along. So tell us, Amanda, how is this people PC issue playing out before the FCC at the moment?
Sure. Comcast recently talked in a filing about sort of a pay-for-privacy model in which folks who are concerned about additional data protection and privacy could pay an additional fee on top of their usual monthly service fee to provide more protection for their data. And the FCC came back with, privacy is not a luxury. These kinds of policies disproportionately affect low-income Americans who are going to end up having a lot more data collected about them. We already know that a lot of low-income communities are already specifically targeted for additional surveillance in a lot of other ways. And this is just sort of a pile on. And in a lot of ways, it's reminiscent of the ways in which certain populations are disproportionately impacted by workplace policies that sort of request that you exchange personal health information on sort of a wellness plan to drop down insurance rates on a monthly or yearly basis. The folks who are most interested in those plans a lot of the time are folks who are low income. They may have long-term chronic health conditions with sort of a set monthly fee for pretty significant medication. And even though it's a lot of personal privacy information, the exchange of a few bucks off a month is sometimes worth it. And sometimes in those situations, it continues to perpetuate that inequality. And the FCC has indicated that that's actually not acceptable. Privacy should not be a luxury only afforded to the very wealthy who can afford it.
What do you think about that, Mike?
Yeah, it's not an issue that I've really been following that closely. Obviously raises some very interesting issues from the FCC's perspective. It'll be interesting to see how that all plays out.
It sort of goes hand in hand with the net neutrality issue, in that if you're able to pay for certain services, and companies might want to build business models around having you pay for certain access to services, that really impacts your ability, the public's ability to use the internet in an even-handed way. So this sort of seems like the other side of that coin. Do you know where I'm going with this, Amanda?
Absolutely. And I think it's interesting in light of the recent net neutrality decision to think about where the FCC is going to go with a sort of widespread privacy for pay proposal. Because I don't think that Comcast is going to be the last company that's interested in that kind of business model. And one of the things that they wrote in their filing was sort of, this is just a continuation of a long legal and policy history of, giving customers choice. If they'd like more features, they can pay for them. And I think we've seen that the FCC may not be so sympathetic to that argument, even though in other contexts that has sort of been the status quo.
Okay, so we wanted to flag that issue for you. I wanted to talk for a moment, since we're talking about legislation, regulation, and policy, about drones, specifically some new rules from the FAA that are going into effect on August 29th. What we have coming later this month is the ability to use drones for commercial purposes if you follow the rules of the FAA, and they're fairly involved, but it's a slight shift from what we've had in place previously, which were specific licenses that had to be granted. This is a slightly different, more flexible, more open regime. And I was going to save this as a resource of the week, but I think I'll bring it up now instead. There's a great website called Know Before You Fly, knowbeforeyoufly.org, which is an education campaign funded by the Association for Unmanned Vehicle Systems International and the Academy of Model Aeronautics in partnership with the FAA to educate prospective users about safe and responsible operation of unmanned aircraft systems, UAS, or drones, as we call them. This website is just invaluable. So if you are somebody who either is a hobbyist and you want to know what sort of requirements are on you from the FAA, and there are requirements on you from the FAA, or if you're someone who, wants to deliver tacos or pizzas or other things via drone, you really got to check out that site and see exactly what's available. The FAA is definitely trying to make this more accessible, strike that balance between safety concerns, privacy concerns. It's really the privacy piece that still seems to be the FAA trying to keep their hands off of that. So maybe other regulators will step in on that front. And commercial concerns, people who want to have very legitimate ideas and innovative ideas about how they're going to use drones in their businesses. I was gone last week at a drone race, the U.S. Drone Nationals, which took place on Governor's Island, just off the tip of Manhattan. And it really opened my eyes to a number of issues, things. First of all, it taught me that not only do people race drones for fun and profit, and that's another little interesting wrinkle, is that the hobbyist rules assume that you are not doing this for profit. So I'm not sure where the drone racers fit. I think they, and probably lawyers more familiar with these provisions, would say that they all fall on the hobbyist side. But I think the FAA regulations are kind of open to interpretation on that, since they talk about whether you're making money on this. And the drone racers, if they win, are definitely in it, for the money. There are pots involved that make it incentivize them for participating in the sport. That drone racing is not the only drone sport, that there are combat drones that are sort of like the battle bots that are built to crash into each other and throw nets at each other. And that's not what was going on at the drone race, but there were some people walking around that were interested in that area. And then the other really cool thing, two other cool takeaways from that event. One is the industry's very tight tie-in with virtual reality. Drone sport racing uses VR on a couple of fronts. The pilots use it to have a first-person view of where their drone is. It's like being a driver in the driver's seat of the drone for them. And secondly, the spectators can have that same perspective from the drivers of the drones to follow the action around the course. So the intimate tie-in with VR in that sport I thought was fascinating. And also a friend of mine who was my impetus for going out there and is a partner at EY. He's been on the show. He's been on the drone episode that we had a while back. His name's Keith Stryer. He had the great insight that drone racing is sort of like Formula One racing is for cars. It's not something that maybe a huge number of people are going to be participating in actively or following as fans, at least not right now. But it's where all the innovation happens that will make its way into other technologies. So it was really fascinating on all those fronts, and seeing as how we have new and more flexible regulations coming out for commercial use of drones, I wanted to highlight that for you all. I'm sure we'll get more drone law experts on the show in coming months. Amanda or Mike, did you want to add anything to the drone discussion before we move on?
I just had a question for you, Denise. What was the most interesting drone that you saw while you were at this event on Governor's Island?
The racing drones themselves are really interesting. They were all pretty similar. Now, I'm sure if you were a racer or a fan, you would take issue with that, that the fine differences matter. But they were pretty lightweight and had carbon fiber frames and two sets of cameras often, one for the first person view and one, if there's any, I don't think the racing drones really ever attach another camera, but it's possible to affix cameras to these drones if the purpose of using them is to go up and surveil something. And that the other thing I found really interesting from the show is how I think drones do get this sort of surveillance rap to them, and that these drone sports will perhaps help overcome that it's not really about flying into your neighbor's yard and seeing what they're doing, or flying around Trump Tower and trying to gaze in or whatever. It's about the sport for these people. So it sort of takes the spying aspect of drones and puts it off to the side. So I liked just how durable they were. They seemed to be something that was far less prone to destruction with those carbon fiber frames than what I've experienced personally in the hobby drones that we've picked up. And we did see several of them smash into the barriers they were supposed to be navigating on the course. And although their pilots were sad, it did seem like, like a race car, they would put it back together and race it again. So, Mike, anything on drones?
Nothing further from my perspective. Very interesting report. Thank you for that.
You're welcome. Let's move on and talk about crimes and justice, and specifically the Computer Fraud and Abuse Act. This first story, again, we're bringing up Pokemon Go. Sorry, had to do it. It's a follow-up from our All Pokemon Go episode we did a couple of weeks ago. We were talking about APIs and how this was a ripe area for legal action by Niantic. And it appears, and Amanda caught this, that Pokemon Go Niantic is actually trying to take on some of these unauthorized APIs, hacked together APIs, API scripts, I guess, that might use the actual API for purposes that Niantic did not intend. And in the course of sending out cease and desist letters, violation of the Computer Fraud and Abuse Act is one of the things they raise, unsurprisingly, since it is very broad and it prohibits unauthorized access to servers and access that exceeds authorization. And that's the federal provision, and some states have parallel kind of statutes as well. Amanda, I imagine you were not surprised to see Niantic starting to go down this road?
No, I think that this was sort of a matter of time, as well as issues relating to terms of service. There is a lot of confusion around whether violating terms of service actually triggers provisions of the Computer Fraud and Abuse Act. That is still a sort of ongoing open question in some courts. And as users continue to, sort of innovate around the Pokemon Go product, that's another possible legal avenue for Niantic to sort of perk up and take issue with if there's terms of service violations. I will note that in the most recent rollout, as sort of a follow-up to the All Pokemon Go episode several weeks ago, the new July 30th update that came out has a lot more built-in safety recommendations. And I'm really curious about sort of the conversation that led to reminders every time you open the app to not drive. And when you walk too quickly, it also alerts you and makes you confirm that you are a passenger in a car if it believes you're in a car.
Ooh, I haven't seen that one pop up yet because I'm not using it when I'm driving. So
a friend of mine recently said that he got that alert and sent a screenshot on Twitter saying New Yorkers really must walk fast because he keeps getting the alert walking around the city when he's not in a car.
That's funny. Mike, any thoughts on cease and desists from Niantic?
Yeah, so I was curious about the claim, and Amanda, maybe you know a little bit more about it. In terms of a violation of the Computer Fraud and Abuse Act, I mean, doesn't one have to show that there's actual damage being caused to the technology at issue? And if so, what exactly is it? Because it's not clear to me.
That's right. Under the Computer Fraud and Abuse Act, there has to be $5,000 worth of damages. I'm not super sure what Niantic is alleging the $5,000 worth of damages is, but we've seen in other recent cases, for example, the recent case involving somebody who used to work at a media company. There was an alleged CFAA issue because that person allegedly shared credentials to log in onto the media site. Content was changed briefly. And as soon as that happened, the company started sending internal emails saying, this is going to cost this many dollars. Here's how much it's going to cost to hire these folks, to sort of create a record of what they believed was going to be the cost. And it's possible that Niantic has or is doing something similar to say, okay, here's one more API. Here's how much money it costs for us to go investigate. Here's how much money it costs for us to patch the issue. But to me, I haven't looked enough at the lawsuit or the alleged lawsuits or demand letters to see what they think that $5,000 in damages would be.
Probably not too hard to cobble together something that would amount to $5,000 in damages. I think in other cases, simply just investigating the damage that had been done was lumped in as part of the company's alleged damages under the Act. So one other CFAA case to pay attention to, this is Facebook versus Vashani, if I'm saying that right, which is pending before the Ninth Circuit. And I bring it up simply because respected attorney, also writer for the Volokh Conspiracy and the Washington Post, Oren Kerr, has gotten involved in the case. He wrote about the case a while ago and found it troubling. Wrote that if he was reading the case correctly, it would the lower court had held that if you tell people not to visit your website and they do it anyway, knowing you disapprove, they're committing a federal crime of accessing your computer without authorization. He said, I think this decision is wrong and that it has big implications going forward. He was actually contacted after that by Stephen Vashani to see if he was interested in assisting with a petition for a rehearing. And he did so. He joined the legal team pro bono, and Marcia Hoffman did as well. And they have filed a petition for a rehearing and rehearing en banc before the en banc panel of the Ninth Circuit. So those are pending, and we will see if they make any headway that hasn't been made yet in that case. I don't know much more about that case, but if Oren Kerr has decided to involve himself, it's one to definitely keep an eye out for. And certainly telling people not to visit your website seems like something that that was not probably contemplated by the legislators when they enacted the statute. Any thoughts, Mike?
Yeah, I mean, it's, the statistics on getting a federal appeals court to rehear something en banc you've got a really significant uphill battle. I think you've got a better chance of the Supreme Court accepting a petition for writ of certiorari than a federal appellate court actually rehearing a case en banc. So, I mean, I think it's a compelling issue. Will be interesting to see if the Ninth Circuit takes it up.
Yep. We'll keep an eye. Amanda, any thoughts?
No, other than just the general issue of we have a lot of lack of clarity around the Computer Fraud and Abuse Act. Denise, as you mentioned, it's not clear that this is exactly what was in mind for the legislators when this law was passed, which was, I'm sure as many of This Week in Law fans know, was passed sort of strongly based on the 1984 film War Games with Matthew Broderick, which was really more of a true hacking issue. And it'll be really interesting to see if this rehearing en banc request is granted, and if so, if it provides more clarity or serves to sort of further entrench the challenges of the CFAA and how broadly it's been interpreted.
Right. Okay, let's move on and talk about some robots. Again, this is sort of a follow-up to the more in-depth show we did a while back on lethal autonomous stuff. There's a good piece at Vox.com about creating rules for how the police can use lethal autonomous stuff, either whether it's autonomous or remotely controlled. I think we're lumping in that article. But what I wanted to highlight for people that I found really fascinating is this project that is part of MIT. It is called Moral Machine. I think it's part of the Media Lab, MIT Media Lab, Scalable Cooperation, and MIT itself. The Moral Machine is a platform for gathering human perspective on moral decisions made by machine intelligence, such as self-driving cars, of course, also such as other more overtly lethal stuff. And what this does is shows you moral dilemmas. It is so depressing. I have walked myself through the 12 scenarios that it presents to you, and I think it presents different scenarios to different people, where a driverless car must choose the lesser of two evils, such as killing 2 passengers or 5 pedestrians. So you're supposed to judge the outcome you think is more acceptable, and the goal of you can also suggest scenarios if you think that they're not getting at the crux of some thorny ethical dilemma that a lethal decision-making system might have to autonomously make. You can help them design scenarios that they can then have other people answer. It's really fascinating just to help them gather this information. So I thought that perhaps our audience might be interested in providing MIT with their 2 cents about the lesser of these evils. Did either of you take a look at this, Amanda?
I just saw that there was a dog versus cats one, which is sort of surprising and interesting. But I actually had a question. When you were going through, did you take the scenario seriously and answer the way that you would like an autonomous vehicle to respond? Or were you just looking to see what the different outcomes were?
I took it seriously, and I think that that's part of the problem of their information gathering. Right? There are probably people that wouldn't do that.
Indeed, I'm sure there's already people who are saying, "Is there a way for the car to just swerve and kill everybody?" And we would like to suggest that, which is troubling because if you're going to crowdsource morals for machines, and it's sort of in the same way that you are curious about reducing algorithmic bias, if you're having human inputs, there's going to be some issues that diverge. You're going to have biased algorithms from biased humans, and you're going to have immoral outcomes from folks who are either doing it for messing with the system for the lulz, as it were, or who actually just have a moral perspective that diverges from what would normally be a majority view.
Yes, and hopefully they can correct for that a bit.
Yes.
One of the variables I found really interesting in going through their scenarios is that there is this aspect you're supposed to factor into your decision making, whether the people to be killed are morally okay themselves. I mean, it factors in, you're presented with whether the driver of the car who's about to crash or the person in the intersection is a criminal, or whether the people in the intersection are crossing against the light or not. That's a variable that comes up over and over again. You know, do you take your life into your own hands if you're crossing against the light? And I think as these systems, self-driving cars being a good example, become more and more prevalent, that you're taking your life into your own hands, because that might well be one of the ways that they're programmed. They're, like an ambulance or a fire truck, that not that they're able to control the lights, but they're able to have information that's fed to them about whether the light has turned or not, and that they make some assumptions based on that, and they're not going to be able to slam on the brakes if you assume. And just coming back from New York, Amanda, my God, people cross against the light there.
Oh, yeah.
It was freaking me out. Don't do that in California. We wait for the light.
No, you don't do that in California. That is how you get a jaywalking ticket. But here, it's a really different situation, and I'm curious about whether, sort of, not necessarily from a moral perspective, but whether social context should affect how autonomous vehicles behave. Because if you tell an autonomous vehicle that anyone crossing against the light is fair game, New York City is in real trouble if they start rolling out autonomous vehicles. Myself included. It's big trouble.
Right. I can just see the disaster movie taking shape as we speak. Mike, any thoughts?
Yes, so I actually went through, and like you, Denise, I took the test very seriously, and it was, I was somewhat troubled by how I rationalized certain decisions as I kind of looked at it.
Mm-hmm.
Like I would go through, and there was, there was one scenario. I think the opening scenario was, at least the one that I was presented with. You're in the autonomously driven car, you've got a child and a mother. And then in the crosswalk, you've got three old ladies. And so you choose between, which scenario, who do you save? And I saved the baby and the mother. And then there were, which seemed to me to be maybe a little bit easier dilemma. I hated being given the choice, and put to the test here, but I did save the baby and the mother in that scenario. The other scenario that was maybe a little bit more difficult that I found myself rationalizing through was, there was one car with three athletes, and then in the crosswalk was three men. And I'm kind of thinking to myself, okay, well, geez, who do I do? These three men, maybe they have families, maybe these three athletes are troublemakers. And so I'm kind of literally going through this calculus, albeit briefly in my head, to see which way I should decide. And then there was another one where I thought, well, it was similar to the first scenario where it was the baby and the mother and the three old ladies. And I thought, well, last time I saved the mother and the baby, so this time I'm actually not going to save the mother and the baby. So it was like, it was interesting how I kind of rationalized my way
trying to come to a kind of equilibrium in your decision making.
Yeah, exactly. Trying to spread the pain, I guess, in some ways. The easier dilemma for me was, there were some scenarios where it was a dog and a cat. Save the animals or save the people. I mean, that from my perspective was a pretty easy situation. It was curious, though, that some of the people that you would be that you would be given the choice to save would be, criminals versus doctors. And I don't know how an autonomous vehicle necessarily can differentiate between the two. But I found myself, when I was faced with that dilemma, of course, saving the doctors versus saving the criminals. So I don't know. It was very fascinating. I encourage people to take a look at it. If nothing else, I think it's an interesting exercise to see how you, if you were an autonomous vehicle, how you'd go about making that determination.
I wonder if actuaries would provide an interesting point of comparison for just sort of normal interactions with the moral machine, because actuaries are trained to sort of make these kinds of judgment calls about, you know what I mean? And when they're appraising insurance policies or what have you, they're using math and statistics to figure out what are the likelihood of potential outcomes? And I wonder what the results of that moral machine input would be as compared to folks who are making more sort of what you were saying earlier, Mike, sort of gut or, trying to reach an equilibrium rather than maybe something that's really solely rooted in a mathematical model. I'd be curious to hear more about that.
You hit on something, Mike, that did completely creep me out while I was taking that, and that is that these researchers at MIT seem to be assuming that the machine will know whether you're a doctor or a criminal or your age.
What happens to the doctor criminal? What happens to that person? I don't know that the autonomous car is prepared for that.
No, that's right. There's some bad docs out there. Let's make bad docs our second MCLE passphrase for the show. And we'll get back into talking about some interesting items. We will get into de-entword and other stuff on the entertainment front in just a moment. But we're going to thank our final sponsor for this episode of This Week in Law, and that is Wealthfront. You invest for the long term for you or your family's financial wealth, but trying to do it yourself, especially the right way, is complex and time-consuming. Luckily, there's Wealthfront. Traditional advisors charge huge fees, between 1% and 3% of what they manage. With Wealthfront, you pay 0.25% a year. That's 25 basis points, 0 commissions, and no hidden fees. That's less than $5 a month to invest a $30,000 account. There are no additional charges for any of Wealthfront's services. With Wealthfront's new portfolio review, you can see if your portfolio is at risk, how diversified your investments are, and what you're losing to fees, even minimize. You don't want to be maximizing your taxes. You want to minimize those, and Wealthfront's going to help with that. You can get started investing today with as little as $500. It only takes a few minutes to sign up. It goes right to work, monitoring your portfolios around the clock, taking action as soon as an opportunity arises. Wealthfront is transparent and accessible. You can view and track all your accounts in one place. Wealthfront can track both your Wealthfront and non-Wealthfront bank and brokerage accounts that they'll provide in a summary of all your assets. You can also see every trade that Wealthfront makes on your behalf in your dashboard, on your desktop, or with their mobile app. Wealthfront's process is based on Nobel Prize-winning academic research and the best investment practices. We've heard from many TWiT fans who have used Wealthfront and love how they can diversify their portfolios and buy stocks from in-demand companies like Apple, Amazon, and Facebook, all commission-free. Wealthfront recently introduced their 529 college savings plan, allowing you to invest after-tax dollars, much like a Roth IRA, and save for your child or grandchild's higher education expenses. And with Wealthfront, you're going to maximize your investment and grow it as to the maximum available amount for that important need in your and your child's future life. Wealthfront manages about $3 billion in client assets, and it's growing rapidly every day. What are you waiting for? Invest in your future today with Wealthfront. Visit wealthfront.com/TWiL to sign up and get your free personalized investment portfolio. You'll see the customized allocation they recommend for your profile. And just for TWiT listeners, if you sign up to invest, Wealthfront will manage your first $15,000 entirely free of charge for life. Join the many TWiT fans who have seen huge success with Wealthfront and claim your offer today at wealthfront.com/TWiL. Thank you so much, Wealthfront, for your support of This Week in Law. All right, let's talk about this rap rave band, shall we? Let's talk about some entertainment stories. So one thing I did not waste time doing in New York, since it got such bad reviews, although I so wanted to see it, was to go see Suicide Squad. It certainly is plastered all over Times Square and had a lot of hype running up to the movie. Unfortunately, apparently the film does not match up with the hype, according to many folks who have seen it. Has anyone seen it?
I have not. I had the same reaction as you.
No, so crickets. We've not seen it. But de-entword has seen it. This is a band that has a style very similar to the very in-your-face kind of punk style of the look of Suicide Squad. And let's see, one of the members of de-entword is Ninja. The other one, and I believe that's who posted is Yolandi Visser. She went on Instagram and posted a little comparison video showing some of their looks versus some of the film's looks. And they're pretty close, and they don't seem to be taking legal action here. They just seem to be annoyed, like, hey, you jocked our look, to use their term. And Mike, I'm curious of your perspective on this. If they were to try and cobble together a legal action, it wouldn't necessarily be copyright. It's almost like trade dress.
I think that's right.
Okay.
I don't know. I mean, I guess it's got elements of both copyright and potential trade dress associated with it. But I think you're right. It would probably fall closer to trade dress / style or manner of doing business as opposed to a copyright infringement claim.
Right. Well, maybe they will talk to some lawyers about it. They are annoyed, and there are some similarities, to be sure. 3 watches on the female character's wrist. What is her name again? Harley Quinn. Harley Quinn.
Right.
Yes. And the graphics, black and white graphics that are very characteristic of the band. Wearing your tattooed torso and nothing else under a trench coat seems to be one of Ninja's looks. So it sounds, they at least have something to talk about. And so far, all they've done is rant a bit on Instagram. So we'll see if they decide to make more of that. Marvin Gaye's estate has made more of something kind of similar against Ed Sheeran. You want to tell us about that, Mike?
Sure. So this was a copyright infringement suit that was just filed earlier this week over the very well-known hit written or co-written, I guess, by Marvin Gaye, "Let's Get It On," 1970s hit, I believe. And Ed Sheeran was sued for copyright infringement by the co-authors of that very well-known song for his song. The name of it's escaping me now, but you kind of hear it all over the place. So he was sued. This was, I should note, the second time in the last several months where Sheeran has been sued for copyright infringement. So, of course, Marvin Gaye, or at least his estate, was very successful within the last couple of years in prosecuting a copyright infringement case against an alleged infringer, Robin Thicke, and ultimately was awarded a multi-million-dollar jury verdict. So we'll see what happens with this case. I was interviewed about it for Hits Magazine, and to me this represents another problematic or troublesome claim of copyright infringement. Yes, you can hear some similarities between the two songs at issue, but the similarities don't with no offense to either Sheeran or the heirs of Marvin Gaye or the co-authors, none of these elements are particularly original, I gotta say. Very basic chord progressions that you see in all sorts of songs, including such well-known hits as Crocodile Rock by Elton John and Power of Love by Huey Lewis and the News. You've got very similar chord progressions, and the rhythmic pattern is very basic, very simple. You could see it in dozens, if not hundreds of songs over the years. So I think this represents another problematic aspect of music copyright infringement, that you can literally take very basic common elements, cobble them together, and then allege a claim for millions of dollars in damages. So I think it's inconsistent, these music copyright claims, with other areas of copyright where courts are more attuned to sans affaire and other types of copyright doctrines. And, I think that, if it were me and I were Ed Sheeran, I'd really be interested in seeing this through to the end to hopefully successfully mount a vigorous and successful defense.
Thinking Out Loud is the song that he's getting sued over.
Thank you.
You're
That's
welcome.
Right.
And yes, and I'm with you. I think, it sounds like the the fundamental riffs and chords and rhythms at the basis of this suit. There, it's almost like genericness in other areas of the law that you would have to just let it go in this case. But we will see if he, the extent to which he pushes back and puts on evidence that he thinks this is not infringement. And I'm assuming that's what will happen here. Amanda, any thoughts about this?
No, the two of you covered sort of all the major points. It'll be interesting to see what he and his legal team decide to do in this case.
Yes. Another thing that'll be interesting.
I'm calling this case Stairway to Heaven Part 2.
Yeah, exactly. Yeah. Or how about Blurred Lines Part 3?
Oh my gosh.
Hopefully not, because I thought the Blurred Lines case, I thought they got it wrong too.
Right.
Never in a million years would I find that those two songs were infringing, or that that they were infringing. I think that's absolutely the wrong decision.
Yeah, I don't necessarily know that I want to see the trilogy all the way through the end. I prefer that it stop at Part 2, keep it as a sequel if we have to keep it at anything.
Yes. Something else that caught my radar this week is another one to watch as it wends its way through the court system. And it's a decision, the jury verdict came out last December in favor of BMG against Cox Communications. And it imposes $25 million in liability for willful contributory infringement against Cox for downloads and other infringements that were taking place, alleged infringements. I don't know, the extent to which they had to prove those infringements in trial, maybe, by Cox's users. So this is Cox getting hit with an intentional willful contributory infringement claim and $25 million in damages in a jury verdict. And the aftermath of this, as I've been reading a bit about the case, is efforts by Cox's insurers to wiggle out of liability here for standing behind their insured. Also, the ramifications for other ISPs here is kind of huge. The reason it hit my radar is even though the jury verdict came in last December, I think it was on August 8th, that Judge Liam O'Grady denied both sides' motions for judgment as a matter of law. Both sides were unsatisfied with the outcome for various reasons that they tried to have the trial court adjust. He issued a 63-page long order that I haven't read yet, but I'm going to read because it seems like it'll go into the very interesting evidence that must have come in at this trial and resulted in a pretty intense jury verdict against Cox here. The good news about this is, well, there's a number of good news items. Number one, it's not the final say, simply because the judge has confirmed that the jury's verdict will stand. Certainly not the end of the line. As anyone who watches this show knows, cases get appealed. I'm sure Cox is going to appeal this. That appeal will go to the Fourth Circuit, if I'm not mistaken. So we'll watch it as that unfolds. The other good news here is that BMG was seeking a motion for it made a motion and was denied an injunction that would have required Cox to prevent or limit further infringement and to hand over users' personal information to BMG on demand. The trial judge said, no, both those things are overreaching on your part, BMG. So what will get examined on appeal is the propriety of this jury verdict of willful contributory infringement. Amanda, what are your thoughts on this?
If I remember correctly, one of the big issues factually was the fact that Cox had what was called a 6 strikes policy. And there seemed to be some sort of not taken seriously effect on both the folks who heard that it was a 6 strike policy, which to some of those listeners didn't think that sounded like much of a policy at all. So I'll be curious to see whether other companies have taken notice of 6 strikes being, to at least some jurors, as a bright line no-go, and what will happen with that whether or not that makes sense as a line drawing tool. But I've also not looked at this long order, and I'll be curious to see exactly what the judge said.
Right. Mike, anything you can add?
Yeah, I actually followed the case through summary judgment. And so this is a case, just to provide a little bit more background for our listeners, that this was a case against Cox for, as Denise mentioned, contributory infringement, because they weren't the actual direct infringers. As an ISP, it was their customer base that was allegedly engaged in all sorts of infringing activity. So Cox defended the case saying, look, we're an ISP, we're immune from liability because we have this repeat infringer policy, and we make sure that we, after 6 strikes, we are able to terminate these users, and we're doing what we're supposed to do in order to avail ourselves of the safe harbor provision under the DMCA. And the trial judge absolutely lambasted them with respect to this repeat infringer policy. As you mentioned, some of the policies that were used had this 6 strike and you're out policy, whereas you could be terminated, but only after 6 instances where you were infringing. There were other circumstances where repeat infringers were terminated, and then the next day or even later that day, their service was restored. So it was effectively a no sort of policy with respect to repeat infringers. So there was a lot of evidence of that type of conduct by Cox, and the jury, I think, was pretty rightfully incensed by it. So to the extent that there's an appeal with respect to the evidentiary basis or finding of liability, I think that's going to be a very tough uphill battle for them, just by the very nature of how it goes when you're appealing from factual findings made by a jury. I don't know in terms of the damages theory, because I didn't follow it that closely in terms of finding out what the damages experts were saying as far as the damages were concerned and how that was calculated. It seems to me that to the extent that there's going to be a success on appeal, it would probably be best to focus on the damages calculation or the damages theory as opposed to the underlying basis for liability, because that seems pretty clear that there was a bad policy here and that there was infringement by the end users, and there was no safe harbor that Cox could avail itself of. So that's my take on the case.
God, it's surprising that they had practices in place that could so inflame a jury and a judge, as it seems like happened here. You would think that the cable providers and other ISPs would get together and try and cobble together best practices that wouldn't result in there being bad industry-threatening law made against them. But it seems like maybe that's not what they're doing, or at least not up until the point of this case being filed. So it'll be interesting to see what happens as this gets examined on appeal. Thank you for the greater background, Mike. Let's look at, before we go ahead and wrap up, bring the show in for a landing, let's look at one case under the Defend Trade Secrets Act, the new act that we've talked about a bit on the show, that has been recently filed and involves My Little Pony. So, Mike, tell us about Ellie Shapiro and what she invented.
Yeah, so Ellie Shapiro is a former employee of, I believe she worked at Mattel, I believe she worked at the Walt Disney Company, and she is a toy designer and apparently, by all accounts, very successful, well-known in the industry for designing toys. She came up with an idea for a new line of, I guess, My Little Pony dolls, which would have these dolls created, and then inside the bellies of the dolls would be a snow globe. And I think there were a few different types of designs that she had come up with. She pitched the idea to Hasbro. I think there was an NDA that the parties had signed, a series of meetings. She presented Hasbro with apparently a very detailed proposal about her line of dolls called Wishables. There was all sorts of marketing initiatives and other things that she presented to Hasbro. And according to the original complaint, Hasbro then took all that material and came out with a very similar type of line, and it didn't pay Ms. Shapiro for that, took all of her alleged trade secrets and infringed on her copyrights. She moved for a preliminary injunction in the case, which was denied. And what the trial court apparently found, I haven't read the order because I can't find it anywhere online, but apparently what the trial court said is it was denying the motion for preliminary injunction because apparently there was enough evidence that the court was convinced that Hasbro was already in the process of developing a similar line of toys, had apparently been looking at it for a number of years or for some extended period of time before Ms. Shapiro presented the information to Hasbro. And that was ultimately recently affirmed by the Ninth Circuit. The case is set to go to trial in September, I believe. And so I'm not sure exactly of this next procedural move, but she then filed, I think, a complaint just earlier this month for, under the Defend Trade Secrets Act, she dropped the copyright claim, and also there's a claim under the California Trade Secrets Act statute as well. So again, as near as I can see, she's alleging these same types of claims with respect to My Little Pony. Not sure why there's a brand new lawsuit that was filed, because it seems like the other lawsuit's still pending and needs to be disposed of. So I don't know. That's what I've seen so far.
Since we're going to move from this into our tip of the week in just a moment, I'm wondering if you can cobble together a tip here for those similarly situated to Ellie Shapiro, a creative person who wants to go to a big brand and pitch an idea. Is there anything she should have done that she doesn't appear to have done here?
You know, based on everything that I've seen, I think she did it right, and she's very experienced with respect to these types of issues. You know, lots of toy companies have submission policies where they'll consider a lot of outside material. Now, the problem that you always face in these sorts of cases is because a company like Hasbro is so big, or Mattel is so big, and they've got this vast army of resources and researchers, you know, it may be that you've come up with something that is completely independent, something totally novel and new that they haven't considered. And if you have, I think your case is going to be stronger. But to the extent that they've already considered similar proposals, or they've got a team of folks that have looked into this particular idea and are exploring it, you know, you've got some issues there as to whether you can claim trade secret protection or copyright protection, even for that matter, with respect to these companies. But it seems like Ms. Shapiro did it right.
All right. Well, another good one to continue to watch. Let's cleanse our palate with our animal selfie of the week. Our animal selfie of the week this week is not just one, but a whole book of animal selfies for you animal selfie aficionados. It is entitled Candid Creatures, How Camera Traps Reveal the Mysteries of Nature by Dr. Roland Keys, I think it is. And just a good reminder that long before Naruto came on the scene and grabbed someone's camera and started taking pictures, science has been setting up camera traps and letting animals capture selfies of themselves for quite some time, enough that there's an entire compendium here of such shots for those who are interested. So wanted to highlight that. Also wanted to highlight, again, Amanda spotted this and tweeted it. These are not selfies, but definitely worth a mention in this context. It is called Hourly Kitten, twitter.com/hourly kitten. Also milk.com/hourly kitten gives you some more context as to why this project was developed. But the originator of Hourly Kitten has decided that they will post one an hour a kitten that is fully licensed and attributed. Mostly it looks like pulled from Flickr's Creative Commons search engine, but probably others as well in the mix. And it's, I guess this was a wonderful case of innovation springing out of frustration. When you read the Hourly Kitten backstory, apparently the creator was relying on a different source for kittens and was disturbed by how many ads there were and decided to do something about it. So now we have Hourly Kitten, which was desperately needed in the world. Amanda, any other thoughts on this?
Yes, I love the Hourly Kitten Twitter feed, but also a lot of those Flickr albums are filled with more Creative Commons licensed kittens. So it's sort of a gift that just keeps on giving.
There we go. Yes. And we always, after the show, when I have time at any rate, I always go through and try and find a Creative Commons attribution picture that we use that sort of reflects the themes that we've discussed in the show. I thought it was interesting reading through the Hourly Kitten about page is they decided not to use the attributions license. They're being even more conservative, even though they have no commercial purpose in having Hourly Kitten available. They just say, why are we using a commercial license? So that all their kittens are licensed for commercial use. So, if you decide you want to reuse one of their kittens, you can do so even for commercial purposes. They say they're doing it because they're being conservative in what they accept, and they don't intend to monetize Hourly Kitten. I thought that just was an interesting side note that people selecting Creative Commons licensed material sometimes go overboard to make sure that they're using something that will not upset the licensor for any purpose. Let's move on to our tip of the week. Our tip of the week is twofold. I alluded to one of the tips earlier, and that is you might want to get in and do some heavy-duty editing of a Wikipedia page for your own edification as well as the world's. This is something Amanda did. Second half of the tip is thank the late, great Barbara Ringer for codifying fair use in the 1976 Copyright Act. Among other things, a few years ago, 2 years ago, I believe, Amanda decided to rework the Barbara Ringer Wikipedia page as part of her attendance at, was it WikiCon?
That's right, WikiCon 2014.
Yes. So I guess did it start out as a stub when you got to it, the Barbara Ringer page?
It was a little bit more developed than a stub, but it certainly wasn't a very long article. And it started off by saying that, Barbara Ringer was in fact one of the main contributors to the 1976 Copyright Act, and called her the first female Register of Copyrights, which I didn't love. And the bio on the side there, Wikipedia includes these very helpful guides to the basic overviews of an article. And it noted amongst her other, professional accomplishments that she was unmarried and had no children, which I did not think was necessary to include in the overview box. So in addition to looking at a lot of primary sources, looking at a lot of really great material from the Copyright Office that was available online, I expanded and reworked her article to include more about her career, her lawsuit. She actually successfully sued for race and gender discrimination to become the first woman Register of Copyrights. And I actually had a wonderful experience speaking with one of her family members who had seen the article and saw that it was briefly featured on the 60 Minutes coverage of Wikimedia and reached out just to say thank you for expanding the article, and I'd love to talk to you more about Barbara.
Oh, that's so cool. And having read through the article myself, I knew nothing about Barbara Ringer before having you on the show today. So thank you so much for doing that research. It seems like you got a lot out of it. We all got a lot out of it. And it's such an interesting story. I almost wish that Lin-Manuel Miranda would decide his next musical was going to be about Barbara Ringer and give some current gloss to an interesting past life.
I would love
that he has successfully done with Alexander Hamilton. Any thoughts on this, Mike? Oh, go ahead.
I was just going to say, especially if all the songs are fair use, that would be cool.
Yes.
Oh, there you go.
Yes. That should be the next project. Lin-Manuel Miranda, we hope you are listening. Mike, any further thoughts?
Amanda, I loved it. I thought it was really well done, and it was just great. I loved the Wikipedia entry. I loved reading the article. Bravo.
Yes,
thank you.
Definitely. Two resources for you this week, both events you might want to think about participating in. One is a cyber symposium coming up on September 8th. This is going to be in San Francisco. From what I can tell, it is free. It is sponsored by the Travelers Institute Insurance Company. Note that they have a strong interest in making sure people know how to secure their systems. I also noted that AIG, different insurance company, was one of the key sponsors of the drone race that I attended last week. So definitely the insurance industry is getting out there and knowing where its risks are and trying to be involved. So the Travelers Institute is one of the sponsors, the NASDAQ Entrepreneurial Center, City and County of San Francisco, CNET, the Berkeley Center for Law, Business, and the Economy. They're all hosting Cyber, Prepare, Prevent, Mitigate, and Restore, an educational symposium helping businesses and organizations tackle evolving cyber threats. So that starts at 11:30 in the morning on September 8th, 2016 in San Francisco at the NASDAQ Entrepreneurial Center if you are interested. Another great thing, now you don't have to be in San Francisco to participate in this, and it's a little sooner. It will be on August 27th. The EFF is hosting what it calls the Great California Database Hunt. You can register at the site that we'll link in the discussion points, or you just look up Great California Database Hunt and EFF. I'm sure you'll find it on 8/27. What EFF is going to do is capitalize on a law that came into effect in California on July 1st. As of then, all local California agencies except schools have to publish inventories of enterprise systems on their websites, which means catalogs of every database that holds information on the public or serves as a primary source of government data. So the problem with this is all of these information sources are housed on different domains at present. And what they're going to do in the Great Database Hunt on August 27th is gather together with everyone's help, hopefully yours, links to all of these data catalogs. They're going to put together a single repository where you'll be able to access from the links. They're going to assemble all of these wonderful California data sources. So you might want to help out the EFF with that on August 27th. And with that, I think we've actually made it through just about everything in our lengthy rundown today. We have some stuff that we'll put off till next week or thereafter. Always interesting stuff to continue to discuss. Amanda, it's been such a pleasure getting to know you on the show today.
Absolutely. It's been such a pleasure to be here. Thank you so much for having me.
Wonderful chatting with you. Anything going on at NYU or the internet and policy? I always forget what IP law. Yes, it's Internet Policy Law Foundry. Yes. Anything at either of those places you want to highlight for us?
Yes, actually, the Internet Law and Policy Foundry is looking for its next class of fellows. And students, current law students, recent grads, folks who are junior in their careers can submit their applications by September 9th. It's a really wonderful community of super bright folks who are just really supportive and encouraging and great to be around. And if you are interested in being in the tech law policy field, I cannot recommend the experience more. It's been a great couple of years.
Wonderful. Thanks for reminding us about that. And do take care. We'd love to have you back on the show sometime in the not too distant future if you're available.
Of course. That would be fantastic. It was great to speak with both of you.
Great chatting with you too. Mike, wonderful to see you again.
Always a pleasure. And thank you so much, Amanda, for being with us today. That was terrific.
All right, folks, thank you so much for joining us all today. We couldn't do this show without you. We're so glad that you participate and get in touch with us between the shows. Please continue to do so. You can reach Mike at twit.tv. I am Denise at twit.tv. Emery, who will be back with us next time, is Emery at twit.tv. Definitely reach out to us. Let us know your thoughts, your suggestions, your guest ideas, your topic ideas, all of that. We love hearing from you, and it's an integral part of how we put together the show. If you've joined us at 11 o'clock Pacific time, then you have joined us live, and you We love it when you do that. You can jump into IRC with us when you do that, but it's not necessary. Our entire archive of shows is available at twit.tv/TWiL. You can look shows up there to your heart's content and delve deep back into our archives. You can also get some information on other ways you can enjoy the show. If the computer screen's not your thing, ways that you can subscribe in iTunes and elsewhere, on Roku, and really whatever your pleasure is, however you like to join us. We're just thrilled that you do. We won't be back next week. Next week, the studio is moving space. So we will be thinking good move thoughts for the TWiT studio as it moves to its East Side Petaluma studio next week. And we will be back with you the following week. Oh, there's some good shots. It's been really fun to watch the time-lapse photography of the studio getting put together. And there is the studio in progress. So we will see you from the new studio in 2 weeks. We hope that you'll be able to join us then. Mark Randazza, a popular favorite with our audience, is coming back on the show then. So we hope you'll join us. And until then, take very good care. Be careful out in the world playing Pokemon Go and otherwise navigating your way through life. We'll see you soon. Bye-bye.
Take care.